Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Hello. This lecture is going to cover limited partnerships, and it will serve as an introduction to limited partnerships, and it focuses on the nature of limited partnerships, the differences between limited partnerships and general partnerships, and limited liability partnerships are discussed in a future lecture. The goal is, these are the goals. Learn these words of terminology: limited partnership, limited partner, and general partner. The differences between general partnerships and limited partnerships, general and limited partner rights and responsibilities, advantages and disadvantages of doing business as a limited partnership compared to other forms of business orgs, and limited partnership organization and management will be covered, and the formalities generally for forming, operating, and dissolving a limited partnership. A little bit about the role of the paralegal will be covered, and if there's time, some resources for further research. So let's go. All right, limited partnerships are a special type of partnership that's created under state statutes. And limited partnerships have one or more general partners and one or more limited partners. And the status of limited partnerships' general partners is very similar to that of the partners of a general partnership. Limited partners are, in many ways, more like investors than partners. And a limited partner's risk is limited to that partner's investment in the limited partnership. Under the RULPA, which we'll discuss we'll discuss that in the coming slides, limited partnership partners are not entitled to participate in the management of a limited partnership's business. And there are, under ULP, the Uniform Limited Partnership Act of 2001, this restriction has been lifted. So it's going to depend on what state you're in, if it goes by RULPA or Uniform Limited Partnership, is going to make a difference in terms of participation in the management. Limited partnerships are considered separate entities for most purposes. And limited partnerships have been popular now in the United States, mostly because of the tax advantages they offer. And limited partners can invest in a limited partnership without risk of personal liability. So with the increasing availability of these new forms of limited liability business organizations, these types of organizations, the limited partnership, is losing some of its popularity. The first Uniform Limited Partnership Act was introduced in 1916. The revised form of Limited Partnership Act, the RULPA, was introduced in 1976, amended in 1985. A new act, the Uniform Limited Partnership Act of 2001, was introduced in 2001. And as of late 2011, most states in the country have adopted a version of RULPA with the 1985 amendments. A few of them have recently adopted the Uniform Limited Partnership Act of 2001. Some states have amended their statutes in recent years so they include provisions for limited liability, limited partnerships. Common law also plays a role in partnerships through case precedent And the limited partnership agreement is essential to creating the organization in a way to operate that operates around the state statutes and common law principles. And so a well-drafted partnership agreement can override many of these default provisions, if you will, such as how profits and losses are shared, the voting rights, and decision-making authority, and the rules for admitting new partners or handling withdrawals of partners. All limited partnerships must have at least one general partner who has personal responsibility for the debts and obligations of the limited partnership. The rights and responsibilities of the general partner are generally the same as the rights and responsibilities of a partner of a general partnership. All limited partnerships must have at least one limited partner who's not personally liable for the debts and obligations of the limited partnership. Limited partners have a few of the rights granted to partners in a general partnership, and correspondingly few of the responsibilities. So one individual may be both a limited and a general. And when that happens, the partner will have the rights and responsibilities of a general, but that partner's contribution as a limited partner will be protected as that of a limited partner. And the interest of a limited partner is considered personal property, even if the partnership assets include land. Under the rule PA, limited partners have no right to participate in the management of the partnership business. Limited partners who take part in the control of the partnership may lose their limited liability status, thus be subject to risk, financial risk. Because limited partners rely on general partners to manage the limited partnership, general partners owe a fiduciary duty to limited partners. Although limited partners have no right to exert control over the limited partnership, they're entitled to vote on certain extraordinary actions taken by the limited partnership. The Uniform Limited Partnership Act of 2001 differs substantially from Rule PA, where limited partnership participation and management is concerned. Under the Uniform Limited Partnership Act of 2001, limited partners are not personally responsible for obligations of the limited partnership, even if the limited partner participates in the management and control of the limited partnership. Management and control is similar to that of a general partnership. And in states that follow the Rule PA, only general partners of the limited partnership have control of the partnership business. Under Rule PA, the following actions do not necessarily indicate that the limited partner is taking part in control: being a contractor or agent of the employee of the limited partnership, or of a general partner, consulting with or advising a general partner with respect to the business of the limited partnership, acting as a surety for a limited partnership or guaranteeing or assuming more obligations of a limited partnership, taking any action required or permitted by law to bring or pursue a derivative action, which we'll discuss in a minute in a separate slide, and requesting or attending meetings. Winding up the limited partnership may involve the limited partner's activities. It may default to that person, so that will happen sometimes, which will be discussed later. And exercising any right or power permitted to the limited partners under the Rule PA and not specifically enumerated in the subsection of Rule PA that this is coming from. So as always, we're looking to the advantages and disadvantages of doing business in certain forms. Some of the advantages of doing business as a limited partnership compared to other types of business orgs include limited liability for limited partners. That's an advantage over other partnerships and sole proprietorships. The flow-through income taxation of limited partnerships is beneficial to most business owners. Compared to interest in general partnerships, the interest of limited partnerships can be more freely transferred. Limited partnerships offer more business continuity than the general or the sole proprietorships. And compared to sole proprietorships and general partnerships, it may be easier to raise capital for limited partnerships because um, there must be more than one initial investor, and subsequent investors may be sole limited partner interests. The disadvantages are several, but most state limited partners may not participate in the management of the limited partnership. And we went through a little bit of that, and they don't enjoy the same flexibility of management as other forms of business organizations. And unlike general partnership, the limited partnership must be formed by filing the appropriate documentation with the Secretary of State or other designated state authority. The legal and organizational expenses for forming and operating a limited partnership may be significant. So the limited partnership certificate is a document filed with the Secretary of State or other appropriate state authority to form the limited partnership. And in the lecture notes, I have a long list of the contents of that certificate, and it depends on whether you're working with RULPA or Uniform Limited Partnership Act of 2001. Not a huge difference, but there are differences nonetheless. And let's see. If there when there's certain information that changes in this, when certain information in the limited partnership certificate changes, an amendment to the certificate must be filed. And most amendments to the limited partnership certificate need to be approved by all general and limited partners. And the RULPA also requires certain documents be kept at a designated partnership office. This would be the current list of and names and address of general and limiteds of the partners, that is, copies of the certificate of limited partnership, copies of the limited partnership income tax return, and copies of all effective written partnership documents. These are in the lecture notes as well. The Uniform Limited Partnership Act of 2001 has a few more requirements in terms of what must be kept in a designated location in the office. Let's see. There are some other exceptions. Again, they're in the lecture notes. You'll be able to read these. The limited partnership agreement, it encompasses the entire agreement among the partners, and so it's not filed for public record. The limited partnership agreement is typically much more detailed than a limited partnership certificate. And many topics are addressed in the limited partnership agreement. The name, the purpose, the address, duration, what kind of contributions are made, the description of the limited partnership assets. The list is long, so I won't go through it. It is in your lecture notes. All right. Changes in the limited partnership do occur, and when there are new general partners, they're usually admitted with only the written consent of all the partners or by other means set forth in the agreement. And additional limited partners may be added in compliance with the partnership agreement as well. The death or withdrawal of a general partner will generally cause the dissolution of a limited partnership unless the agreement provides otherwise. A general partner who withdraws in violation of the partnership agreement could be liable to the other partners for any damages that his or her withdrawal incurred. And the death or withdrawal of a limited partner generally does not cause the dissolution of limited partnership. Limited partners may usually withdraw from the limited partnership in compliance with the limited partnership agreement. The financial structure of a limited partnership is as follows. Limited partners must make contribution to the limited partnership, and that contribution is placed at risk. The profits and losses of the limited partnership are shared as provided in the limited partnership certificate or limited partnership agreement. So if the formula for allocating profits and losses isn't specified in limited partnership certificate or agreement, the profits and losses are allocated on the basis of the value of contributions made by the partners to the extent they have not been returned to the limited partnership. The income, still on the financial structure, the income of the limited partnership is reinvested in the limited partnership or dispersed to the partners pursuant to the agreement. And distributions cannot be made to partners if after those distributions the partnership's liabilities will exceed the partnership's assets. So they can't go into the red. The limited partnership's income or loss is reported annually to the IRS on Form 1065, which is a partnership return. This form reports the income allocated to each partner. Partners must report and pay their income taxes on their share of the limited partnership's income, whether or not that income was distributed to them. All right, limited partnership, dissociation, dissolution, and winding up. The RULPA provides that the limited partnership is dissolved and its affairs must be wound up when one of the following events occurs. We've got the time period specified in the certificate has expired. Specific events that are in the partnership certificate occur. All the partners consent in writing. An event of withdrawal of a general partner occurs, and a decree of the judicial dissolution is entered. If the limited partnership dissolves, this limited partnership certificate is simply canceled by filing a cancellation certificate of the limited partnership with the Secretary of State or other appropriate authority. The business of a limited partnership may be wound up by any general partner who has not caused a wrongful dissolution. If there is no such general partner, the limited partnership may be wound up by a limited partner. And that was why I saved that thought earlier. So in most states, the statutes provide that assets of a dissolved and limited partnership must be paid out until they're exhausted. So there's an order of priority. First to creditors to satisfy liabilities of a limited partnership. Second to partners to satisfy distributions due them under the partnership agreement. Third to partners in return of their contributions. Fourth to partners as a return of their partnership interest in the same, and this would happen in the same proportion in which partners share distributions. So derivative actions come up a couple of times in this book and in this lecture series, and I thought it would be a good idea to explain what these are. So under the RULPA, limited partners have the right to bring derivative actions in right of a limited partnership to recover a judgment in the partnership's favor. So derivative actions may be brought on behalf of the limited partnership if the general partners with authority have refused to bring an action, or if an effort to cause those general partners to bring the action is not likely to succeed. I do apologize, I see one typo on here on the demand requirement. This is looking to a corporation. I didn't think to that when I found this information in another book or in a book that I didn't even think it was it isn't expressing the RULPA because it's talking about a corporation. But this purpose, standing, demand requirement, court approval, and recovery is all the same. A derivative action is basically the purpose of it. The primary goal is to protect the interests of the limited partnership, not corporation, and its shareholders by addressing breaches of fiduciary duty, mismanagement, or misconduct. So there has to be a partner that is a shareholder, that would, instead of a shareholder, then they'll bring that action. There needs to be a demand made on the company's board of directors, or in this case, the limited partnership folks. And there needs to be a court approval, and it has to be in the best interest of the limited partnership. And the recovery goes back to the partnership, not to the not directly to the partners. All right, there are also family limited partnerships, and they're used for estate planning purposes, funded with family businesses and other family assets, typically to protect them from creditors and others to a certain extent, to the extent possible. The paralegal's role, research is always a role in paralegal. Uh, Licensing requirements for limited partnership businesses, researching state law concerning the role of partners and restrictions of their participation in the management, and to prepare certificates, the partnership agreement drafting, and tax ID information that needs to be had. And in addition, the certificate being filed by someone, the paralegal is often responsible for that, and have a method for retaining partnership methods needs to be set up, and assisting with minutes or limited partnership meetings, and preparing the amendments, if there are any, to the certificate and agreement, and assisting with the preparation of the partnership's income tax return and Schedule K-1s for the partners. Those are the tax forms. And winding up and dissolving a business if that is the case. So this concludes the limited liability partnership. Limited partnerships lecture for today. Be sure to check the lecture notes. They'll give you all of this in detail, and also notice that there's these areas that I mentioned on some of these slides that I didn't bother to go into the long diatribe on. There's some good information in the lecture notes for you. So be well. Thank you very much. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.